Bom, dando continuidade então aos nossos trabalhos, agora sim com a tradução do nosso tradutor aí, o professor Levinson, então vai proferir a sua conferência com a tradução sucessiva ali do nosso profissional. Por favor.
First, I want to thank the organizers of this. I'm very, very happy to be here. I will also repeat what Professor Michelman said, that I certainly hope that there is time for questions and discussion, because I'm sure there are significant differences between the United States and Brazil, and quite frankly, I'd like to learn more about those differences and similarities that exist from any questions you might have. I want to begin.
Primeiramente, eu gostaria de agradecer a todos, principalmente a organização, a convite. Justamente, eles percebem que tem uma grande diferença entre o Brasil e os Estados Unidos, eles estão dispostos a aprender muito mais. Ele vai começar o fala, mas eu gostaria, da minha parte, primeiro eu sou canadense, então se eu tenho alguns erros, então não tem problema.
I want to begin with an article and a case. The article was Professor Michelman's in 1968-69 called Protecting the Poor from the 14th Amendment, in which he offered a very interesting, I thought, plausible reading of the United States Constitution that would indeed have legitimated reading the Constitution to constitutionalize at least certain aspects of a social welfare state. He based this article not merely on the thought of John Rawls, but also on some cases that had been decided by the United States Supreme Court in the late 1950s and 1960s in what we have learned to call the Warren Court. The most important case in some way was a voting case in which one of the states had charged a poll tax. That is, you had to pay $1.50. That would be, I think, about $3.50 in order to vote. The Supreme Court struck that down, saying not simply that it was outrageous to charge people in a democratic society in order to vote, which would have been a thoroughly convincing way of responding to the case. But instead, the majority said that it was irrational to link the ability to pay to the enjoyment of this aspect of membership in the state. And the language, at least, went way beyond voting. Let me give you an example. In order to have a job in most large cities, you need access to public transportation. Buses, subways, whatever. What if you can't afford it? Does that, and let's assume that the buses and subways are public. Does that mean that I should be able access to jobs because I can pay what might be a relatively small amount, but I have the money. What if you don't have the money? What if you find a subway fare or a bus fare to be a genuine imposition because you're also worried about feeding yourself or taking care of your children or buying medicine? Should the state be able to charge the poor to ride the buses? Or if they have cars, to cross bridges that charge tolls? This particular case suggested that the answer might be yes. That is, the state should not be allowed to charge at least the poor for public transportation or anything else the state sells. It can charge those who can afford it, but those who can't afford it should get the good either at a discounted price or perhaps for nothing at all. So there were a lot of people who read Professor Michelman's article and who read this and other cases that he built on and said, we're building toward the absorption of social rights into the United States Constitution. And Professor Michelman, plus these cases, showed the way. What happened? The answer is deceptively easy. Richard Nixon was elected president in 1968 with, I would point out, 43% of the popular vote. We have a strange way of electing presidents in the United States. Quite frankly, I think you have a better way of electing presidents, whether or not you're happy with the particular result of the election 2 weeks ago. Richard Nixon, not surprisingly, and I don't even mean to be criticizing Nixon, this is what you get to do if you win the presidency. You get to appoint judges who are relatively sympathetic with your views rather than the views of your opponents. One of Professor Michelman's colleagues at Harvard, Cass Sunstein, has argued that if Senator Hubert Humphrey had won the election in 1968, he would have appointed judges who shared Professor Michelman's views. And we would have had the realization of the vision that Professor Michelman outlined. That, of course, did not happen. And so now I turn to the key case on top of the article. The case arose out of Texas, San Antonio, about 120 kilometers from where I live in Austin, the state capital. At that time, the suit was brought by people who lived in the part of San Antonio called Edgewood. They got the students in Edgewood who were largely African American and Mexican American, got far fewer dollars than the students who lived in a place called Alamo Heights. And the language in Texas is Anglos. You're Anglo, African American, or Hispanic. Now it turns out there are also a sizable number of Asian Americans, particularly in Houston. But that's the basic demographics of San Antonio. And so the argument was that there were these great distortions in funding. In fact, in 1989, and that's only 25 years ago, Texas's wealthiest school districts spent the equivalent of 50,000 reals on each student. And the poorest districts spent the equivalent of 5,000 reals, a gap of 10 to 1. So the case was brought, Rodriguez versus San Antonio Independent School District. And the argument was that the way Texas financed its public schools was unconstitutional because it generated these huge gaps between rich and poor, between Anglos and non-Anglos. There, you could play the case either way. They lost by a 5-4 vote. And not surprisingly, the Nixon appointees provided the key vote to reject these arguments. So what the court said is that there is no fundamental right to education in the United States Constitution, nor does the Constitution speak to these kinds of gaps between the rich and the poor with regard to education financing or any other kind of financing. We could talk about health, obviously. We could talk about transportation. We could talk about housing. The modern state is involved in everything, and you can certainly find these gaps. Now, there was a footnote in which they said, well, if the state didn't provide any education at all, if the state abolished public schooling and made education entirely dispensed by the market, then maybe poor people would be able to sue if they could make a claim you're getting no education at all. But in fact, every American state supplies public schools. So what happened after Rodriguez? Most American law students, I'm quite confident, would say, well, that was the end of it. As Professor Michelman so eloquently put it, the Supreme Court said, shut up. By one vote, but 5 beats 4 every day. And so what American law students learn correctly is that the United States Constitution, at least as interpreted by the United States Supreme Court, doesn't include much, if anything, in the way of social rights. There were other cases that came up after Rodriguez dealing with a number of other rights in which the court was equally indisputable. But then something very interesting happened. And by the end of my remarks, you may know more about the American constitutional system than many, many American law students and American lawyers, because most American law students and American lawyers believe there's only one Constitution in the United States. That is the United States Constitution. But as Professor Michelman pointed out, there aren't. There are 51 constitutions in the United States. The national constitution and the state constitutions. And one of the things we might talk about in the questions afterward would be similarities and differences between the American federal system and the Brazilian federal system. But it's important to realize that each of the states has its own constitution, its own judiciaries, its own legal cultures at times, and simply an alternative path in which lawyers can litigate. So having lost before the United States Supreme Court, and let me say, I'd be interested to know what Professor Michelman thinks. When I teach Rodriguez, I always find myself truly torn. I think it is a 5-4 case, in the sense that it's really, really difficult to know how much one wants a single court with 9 members that might turn out to be 5-4 to make policy for the entire United States with regard to education or healthcare or any of the other topics, as opposed to these decisions being made at the state level. So in any event, what you have following Rodriguez, encouraged in part by the justice Professor Michelman clerked for, William Brennan, who wrote another famous article, also published in the Harvard Law Review in the mid-1970s, reminding lawyers that states have constitutions, and if they lose at the national level, they might think of reading their state constitutions and litigating at the state level. So that is done in Texas, in New Jersey, in something like 46 of the 50 states. In Texas, say in 1989, the variation was 10-1. By today, the variations are much, much smaller. And this is true in some other states as well. Now, I want to conclude my opening remarks, because I think it's important that we have a conversation and then some questions and comments, by noticing some of the interesting, at least to me, questions that arise with regard to the state court litigation. First of all, it's very, very important to note that what Professor Michelman was defending, this was true in his classic article, this is true today, is what he calls a minimally adequate provision of resources. This is very, very different from demanding equality of resources. Let's go back to Texas in 1989. You could believe that it is outrageous that the students living in Alamo Heights, literally a mile or two from the students living in Edgewood. We just came from Rio. It's as if we're talking about, I think it's the Lobone district, and talking about the favelas, which are very near one another, relatively near one another. So you might pound the table and say it is outrageous that you have this inequality, and therefore litigate on the basis that the spending should be made relatively equal. Or you can litigate on the basis that inequality itself is not the constitutional outrage. The constitutional outrage is that 5,000 reals is not enough to provide a minimum adequate education. And what judges need to do, if they're receptive to these kinds of claims, is not to try to move towards some kind of mathematical equality, which will require, among other things, massive redistribution from the well-off to the less well-off, but rather to try to make sure that those who are underserved get what they need in order to make them capable of living in a modern political, economic, social order, even if it remains the case that those who are well off can enjoy greater resources, but still those who are poorly off will have access to some minimum. As I say, some of the judges in some of the states said, we really shouldn't be handling issues like this at all. We'll leave it to the legislature. But most state courts responded affirmatively. And some quite remarkable things have happened. But it's interesting that in at least one state, the focus was on minimum adequacy. And there was very, very large-scale support throughout the state for genuine, important increases in social spending. Because it's very, very difficult politically to say, I don't care that there are significant numbers of students who aren't even being prepared at a minimum level to get a job or to be able to read and write in order to be able to vote intelligently. It's much harder politically to sell the argument, not to make the argument, but to sell the argument that it is an outrage that we have inequality in our society. Because the only way to overcome inequality is to take from the well-off and redistribute to the less well-off. I don't know if the name Robin Hood has any meaning in Brazil. The English, depending on your view, either the bandit or the hero who robbed from the rich to give to the poor. The Texas Supreme Court focused on equality so that the legislation passed by the legislature quickly became known as the Robin Hood Bill. And politically, it's not good news to have your legislation described. Now, let me finish, though, by looking at some of the peculiarities of the American judicial system at the state level, not the national level. National Supreme Court judges, or all national federal judges, have life tenure. They're appointed by the president, confirmed by the Senate. They're never, ever going to face an election in order to get on the court or to remain on the court. It's also the case, increasingly, that members of the federal judiciary have remarkably little experience in the political world. This wasn't always the case. Earl Warren had been governor of California and ran for vice president of the United States in 1948. If you look at the members of the Supreme Court during that era, they had very distinguished public careers. Most of them did, before getting on the Supreme Court. It's not, I don't mean to cast aspersions, to be unduly harsh about the current members of the Supreme Court, at least one of whom is a good friend of both of us. But it's still, or I guess two, but it's still the case that no member of the current Supreme Court has ever held elective office, has ever run for office, has ever managed a complex bureaucracy. If you look at state court judges, on the other hand, the first thing you have to know is that most of them are elected. They're not appointed. Even if they are appointed, the ones who are appointed, they often have to engage in elections after a certain number of years in order to be retained on the judiciary. Precisely because the judicial offices are elective offices, it is often the case that members of state judiciaries have had previous political experience, that they will be what political scientists call issue entrepreneurs. In some cases, and this was true in Texas, a legislator who was notably unsuccessful in getting programs passed by the Texas legislature, which was too conservative, ran and was elected Chief Justice of the Texas Supreme Court, and then wrote into Texas constitutional law more or less what he had hoped the legislature would do. In New Jersey, another state in which I lived, although this Supreme Court justice had been appointed by the governor, he had been a very popular, well-respected governor of New Jersey before becoming Chief Justice of New Jersey. He was completely unsuccessful in getting the New Jersey legislature to pass an income tax. But as Chief Justice, he was able to bring pressure to bear on the legislature so that now New Jersey has an income tax. It is another feature of this state litigation that there are many, many cases in most of the particular states. There have been 26 decisions in New Jersey over the last quarter century. There have been about a dozen or so decisions in Texas. What this allows is the description of the relationship between the judiciary and the legislature, and for that matter, the judiciary and the electorate, given that they could be scared of the electorate. They might be thrown out of office. It leads to a certain kind of dialogue that judges have to be very sensitive as to how hard they can push. But something very interesting happens also. Legislators may be grateful to be able to say, well, we really didn't want to do it, but the courts forced us to. So it's a kind of very delicate ballet in which the court supplies cover, an excuse for legislators to do what they might claim they don't want to do. This obviously requires political skills. It requires judges to know how hard they can push without being voted out of office, or without the legislature engaging in a certain kind of revolt. And so it raises real questions as to what kinds of people you want on a court. And the answer isn't, I believe, that you want everybody on a court to be just the same. Rather, a court, I think, is like a team, or like an orchestra. And you want people with different skills who play different instruments. But it seems to me a very, very good idea to have on a board, whether it's elected or appointed, some people who have demonstrated genuine political skills. The Belgian Constitution, for example, requires, I think, that half the members of the Belgian Constitutional Court be former members of Parliament. Quite obviously, the United States Constitution does not. No state constitution requires this. But as I say, it often turns out to be the case that people will go from the legislature or from being governor or being attorney general to the state Supreme Court, and they bring their knowledge and their skills with them. And so I think that what Professor Michelman has done is to outline not only some very, very powerful questions of constitutional theory, but to the extent that one does want judges to play some significant role in implementing a social welfare state. And implementation is key. Quite frankly, it's relatively easy to learn how to articulate a right at a very abstract level. The difficulty is implementing that. The devil is in the details. And so what one is talking about is not the part of a judicial opinion saying, because of this and because of that, we hold there's a right to medical care or to education, but rather by saying, okay, what does that really mean in terms of budget, access, the time dimension, today, next year, 10 years, and therefore what sorts of judges you really would trust to engage in the implementation and the inevitable dialogue and bargaining process. And there is a difference between dialogue and bargaining, which we can talk about if you like. But people who have skills in that, as well as skills in presenting standard model legal arguments at a very abstract level.